Today's hearing has been 2 years in the making. In a rush to appease the left, Gary Gensler, the chair of the Securities and Exchange Commission, proposed a nearly 500-page climate disclosure rule in 2022, which, by the SEC's own estimate, would cost companies billions of dollars to comply. And how did Chair Gensler respond? He doubled down on it. Chair Gensler ignored the warning from the Supreme Court, which ruled in West Virginia versus EPA that the EPA had exceeded its statutory authority, relying on ambiguity as constituting an implicit delegation from Congress. Chair Gensler ignored the warning from the Fifth Circuit Federal Court of Appeals, which ruled against a separate SEC finalized rule about share repurchase disclosure. In that opinion, the court rightfully held that the SEC acted arbitrarily and capriciously in violation of the Administrative Procedure Act when it failed to respond to petitioners' comments and failed to conduct proper cost-benefit analysis, close quote. And finally, Chair Gensler ignored his own Inspector General, who concluded that the SEC faced serious management and performance challenges, raising significant concerns that the agency was attempting to enact too many rules too quickly. And that has been a constant theme that we have heard, is the deluge of rules that have come at all sides and trying to sort through that. He has finalized nearly 36 rules, with more than 20 remaining to be finalized. The fast-paced rulemaking over the last 2 years has raised serious questions about how important Chair Gensler views the internal economic analysis conducted by his agency, if there is any. Last year, the subcommittee launched an investigation into the climate rule and the SEC's process to propose and finalize the rule. We've requested documents, conducted transcribed interviews of current SEC staff, and held multiple hearings about the SEC's work on this rule. In response to the committee's request, the SEC has flooded the committee staff with tens of thousands of pages of unresponsive documents and very few answers. You might ask, like what kind of documents? I'll give you one great example. My congratulations letter to the chairman being appointed chairman was one of those documents returned to us as being open and responsive. I had that one in the file already. Given his lack of cooperation and the content of the material turned over to the committee, I can only conclude that Chair Gensler does not really want us to see the flimsy basis on which he has crafted this rule. Additionally, the SEC's climate disclosure rule blatantly undermines the Commission's existing materiality standard. Under the principles-based materiality standard, a company must disclose information to prospective investors and shareholders so that they can make informed investment decisions. The SEC should not statutorily redefine the materiality standard to prescribe climate-related disclosures for all public companies, even when a reasonable investor would not find such information important to their investment and voting decisions. On Friday, just 9 days after the SEC finalized the climate disclosure rule, judges in the Fifth U.S. Circuit Court of Appeals granted a temporary stay. The court's decision signals the SEC's authority to develop, finalize, and implement a climate disclosure rule is in jeopardy. And let me conclude with this. In the 2 years since the climate disclosure rule was proposed, we have witnessed an unprecedented assault on our capital markets. The Commission finalized the climate rule despite no clear congressional authorization. Although Chair Gensler has repeatedly reminded the public he is not a, quote, climate regulator, which we do agree on, under his leadership, the SEC has strayed far from its clear statutory mission and certainly its historic traditional mission. Investors should know that the SEC's overreach will significantly hurt our economy while serving as a boon for special interest groups and far-left activists. Unless he radically alters this approach to our capital markets, Gary Gensler's legacy will be that of an overzealous bureaucrat who has repeatedly been reined in by the courts. I want to personally thank the members of the committee who traveled from their districts, who are being with us here this morning, and to the witnesses, thank you very much. We very much look forward to this, and I commend your willingness to be here with us this morning.